Hey guys, welcome back to Study Time Anytime YouTube channel. We're continuing the series of Canadian Constitution 1982 and today we'll start from 12th article, treatment or punishment. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. This is another fundamental freedom given by the Constitution to everyone and not only to the citizens of Canada. This article says that everyone has the right. Now, everyone also includes the animals. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. So, no one can be treated with cruel or unusual treatment, or they can be given any punishment. This is the right. Next is self-crimination. A witness who testifies in any proceeding has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceeding except in a prosecution for perjury or for giving of contradictory evidence. Now, what this article says, it is saying that there is a witness who is giving a testament or who is deposing before a court in any proceedings. He has the right. What kind of right? Not to have any incriminating evidence so given and used to incriminate that witness. So anything that may incriminate the witness or put him in a criminal case or proves something that is criminally punishable, he has the right not to have any incriminating evidence in any other proceeding. Such kind of witness that may incriminate him in any other case. Suppose A is deposing in a case of a murder, and in that case he says that he was present at that time in Ontario and the murder happened at Vancouver, and in that witness it is found that the other murder that might happen at Ontario, then that might be committed by A. So that in this case A is having the right. His evidence cannot be used to incriminate him in any other proceedings, but there is an exception. What exception is that? That prosecution is for perjury or for giving a contradictory evidence. In that cases, this right is not available. Moving forward, interpreter. Moving forward, interpreter, which means the language barrier, if any. A party or witness in any proceeding who does not understand or speak the language in which the proceedings are conducted or who is deaf has the right to assistance of an interpreter. So he can get the he can appoint an interpreter if he does not understand the language in which the proceedings in the courts are going on. Further, if he is a deaf, then also he can take the assistance of an interpreter. Moving forward, F starts equality rights. 15. So here you can see that from here you can see that there are general guarantee of equality in this chapter. Equality regardless of gender, equality regardless of skin color, equality regardless of origin, equality regardless of race, equality regardless of religion, equality regardless of age, and equality for persons with disabilities. So there are total 8 equalities that are provided. So equality before and under law and equal protection and benefit of law. Every individual, just concentrate here again, it is saying that every individual. So it is not again limited to the citizens of the Canada. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination on number 1 race, number 2 national, number 3 ethnic origin, number 4 color, number 5 religion, number 6 sex, number 7 age or mental or physical disability. So these 7 rights are provided in this single article. Further affirmative action programs, subsection 1 does not preclude any law, program or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age or mental or physical disability. Here they are saying that if the government starts any program which is for the benefit of those people who are discriminated or are disadvantaged because of above mentioned 7 disabilities, then the equality, it is an exception to the first part of this article 15, the subsection 1. At that time you cannot go to the court and say that it is against the right of equality. This is a special exception given to these people. Moving forward, the official language of Canada. So article 16 says that official languages of Canada, English and French, these two are the official languages of Canada and have equality of status and equal rights and privileges as to their use in all institutions of Parliament and Government of Canada. But there is another point here, another subsection, that is official language of New Brunswick. English and French are official languages of New Brunswick and have equality of status and equal rights and privileges as to their use in all institutions of the legislature and government of New Brunswick. So this is just another subsection. Languages are same. Advancement of status and use. Nothing in this charter limits the authority of Parliament or a legislature to advance the equality of status or use of English and French. So there is no limitation upon the Parliament to increase the access of the or status of equality of English and French in the coming period. Then further 16.1, it says that English and French linguist communities in New Brunswick. So here the English linguist community and the French linguist community in New Brunswick have equality of status and equal rights and privileges, including the right to distinct educational institutions and such distinct cultural institutions as are necessary for the preservation and promotion of those communities. So in New Brunswick, when there are 2 communities, one English linguist and another French linguist, at that time they have the equality of status, they have equal rights and privileges, and including the right to distinct educational institution. They can open their different distinct educational institution and cultural institutions also for the purpose for those educational or cultural institution is the preservation and promotion of those linguistic communities. Second is the role of legislature and government in New Brunswick. The role of legislature and government of New Brunswick to preserve and promote the status, rights, and privileges referred to in subsection 1 is affirmed. Next, Article 17, Proceedings of the Parliament. Everyone has the right to use English or French in any debates or other proceedings of Parliament. Proceedings of New Brunswick Legislature. Everyone has the right to use English or French in any debates or other proceedings of the Legislature of New Brunswick. So, again, the languages are same. So, we'll then Article 18, the parliamentary statutes and records. The statutes, records, journals of parliament shall be printed and published in English and French, and both language versions are equally authoritative. Similarly, for New Brunswick, the statutes, records will be in English and French. Then Article 19, proceedings in the court established by Parliament. Either English or French may be used by any person or in any pleadings in or process issuing from any court established by Parliament, and similar is for the New Brunswick. Article 20, communication by public with federal institutions, any member of the public in Canada. Now, important to note here, any member of the public in Canada has the right to communicate with, to receive available services from any head or central office of an institution of the Parliament or Government of Canada in English or French, and has the same right with respect to any other office of any such institution where there is a significant demand for the communication with and services from that office in such language, or due to the nature of office it is reasonable that communications with and services from that office be available in both English and French. So whenever public needs to deal with the federal institutions or any for any services, then these both languages are equally usable, compatible, and you have the right to communicate in those languages in Canada. Similar is in the case of New Brunswick. So continuation of existing constitutional provisions, nothing in the section 16 to 20 or abrogates or derogates from any right, privilege or obligation with respect to English and French languages or either of them that exist or is continued by virtue of any other provision of the Constitution of Canada. Continuing the article 22, rights and privileges preserved. Nothing in section 16 to 20 abrogates or derogates from any legal or customary right or privilege acquired or enjoyed either before or after the coming into force of this charter with respect to any language that is not English or French. So nothing pertaining to the rights and privileges or the provisions that earlier existed has been changed or abrogated or derogated in case of English and French languages. So this is the end of the video here. We'll continue the minority language and educational rights from our next video. Thank you very much for discussion. If you have any question, then do comment, and if you like the video, press the like button and share the video as much as possible, because this is the initiative to provide free education to the entire Canadian students. Thank you very much for discussion.